Solomon Law Group versus Dovenmule.
Thank you. May it please the court. I guess that means I'm up. This
You're
is
up.
Sandy Solomon again, and there are two grounds for our claims for attorney's fees. The first is 57-105, and the second is 768.79, the offer of judgment or proposal for settlement. Let me just address briefly, without repeating myself, this case was dead before its commencement, and they have nothing. And if they had anything, they had every opportunity to take what all discovery and to lay out whatever it is. And after all, you're talking about what we now know as the federal standard, the CELOSEC standard under 1.510. And in order to be able to prevail on the summary judgment, certainly under the current rule, all I have to show is that they can't possibly meet their burden, and then they have to come forward with their obligation, with their evidence. And
Mr. Solomon, let me ask you, just out of curiosity, why did Judge Huey rule the way he did on the 57-105 fee claim while calling it a close call? What tipped him to the denial of that motion?
I have no, I really do not have any idea. Judge Huey has a lot to say, but I didn't understand that it was anything that made a difference. I cannot fathom how in the world there is any cause of action for legal malpractice, or, as Ms. Fitzgerald aptly notes, breach of fiduciary duty carries the same elements and the same burdens. And under these circumstances, they had no case that they ever pled, notwithstanding the amended pleading, that could ever satisfy the but-for requirement. And now we have that admission glaring, and that was glaring to us from the outset. And even though we took this testimony from Mr. Complin, he was as confused as could be. If you read his whole testimony, that was the precursor to this entitlement hearing, because Judge Huey bifurcated determination of entitlement from amount in order to have this quote unquote evidentiary hearing. And I explained how we felt about the case. He had ruled that we were under no circumstances ever responsible for the result or for malpractice. And then he said it was a close call, and I didn't understand how or why that was. And all I can say is that.
Yeah, I mean, and again, we don't know what was in Judge Huey's mind, but might there have been some confusion caused by the opinion in this court's opinion in the underlying Irwin case, where the opinion both talked about failure to assert the waiver defense, and then also talked about the inadequacy of the waiver. Yeah. And so might that have been, if that was Judge Huey's thinking, would that have been enough to avoid 57-105 fees?
No, sir. I don't want to be disrespectful to Judge Huey, but I can't read his mind on this. It was.
Or to Judge LaRose.
Yeah, well, and yeah, I mean, Judge LaRose did go into some detail to spank us, but I didn't take it as a spanking because we knew. I mean, I certainly know. I've chaired the Civil Procedure Rules Committee and the Appellate Rules Committee. I know the rule; it's not a problem. But we didn't have anything to assert, and if you don't have anything to assert that is going to carry the day, making, as Mr. Complin testified at that hearing, just file a general denial. No, sir. There's a legion of cases that say that's not proper. And even if there weren't a legion of cases, what good does it do at the end of the day? And then when you file the motion for summary judgment, what are you going to say in the motion for summary judgment are the facts that say that they waived it, or that you satisfied the burden, or that there was substantial compliance? And by the way, the case that they cite for substantial compliance does not say that. It was a paragraph 22 case that Daddick I can't remember exactly the name of the case, but the case that they cite and that they rely upon to show that it was substantial compliance was the difference between adding the word "you may assert" these defenses, you may reinstate. But it had all of the letter that they were talking about had every other element precisely as required by paragraph 22, and it was sent in a timely manner. That's substantial compliance. Where is substantial compliance here when you got a call from Kim DeRuin that said that nobody refuted, that says, my husband's sick. I need a little bit of reprieve. Can you help me? And they say, no, you got to do a full modification package. And she says, that's insane. I just need a little bit of a reprieve. He's not in work. And that's what ticked the trial judge off in Pasco County in the DeRuin case. Why Judge LaRose and the panel decided to go with the detailed discussion about the need to file the reply and all of that, I don't know. And that may have confused Judge Huey, although he's a very bright jurist. There's no question about that.
Well, I think it wasn't a question of whether Judge Huey was confused. I think it was a question of whether, for purposes of the showing necessary for 57-105 in terms of knew or should have known there was, no merit, whether that might have sufficed to make it a close call versus.
But I made the same argument here before him and said, what is it that they wanted me to plead? Tell me what it is that I should have gotten, or I should have gotten from them. What is it if I took her deposition and his deposition and I said to them, okay, did they ask you, okay, what would you have said? And what was your goal? It's all laid out in her testimony, in her declaration, in what she testified before the trial judge in Pasco to get her fees and upset the judge to the point of a 2.5 multiplier. Who heard of that? I mean, that's unheard of. And it was so insane. And now he says it's a close call. I don't understand what that is. And then he takes issue with my offer of judgment by saying, no doubt, the form of the release, which I didn't even have to attach. I could have just left it on the wording of the document itself. It didn't include any mamby-pamby stuff. It turns out there was a typo for which I take responsibility in it, but it didn't change the meaning of it. It was consistent throughout. You can't sue Solomon Law anymore. That's it. Forget it. Done. Whether it's in this case, because there's no confusion, because in this case, it was only based upon something that happened in the DeRuin case. So I added the separate paragraph that said, so that there's no confusion. If you're claiming we did something wrong in the DeRuin case and you didn't assert it in this case, it's gone too. It's by and against, and it says it that way 3 separate times. Judge Huey says, well, it's confusing. It's patently confusing because there are all these other lawsuits. No, there aren't. You already reversed the denial of my counterclaim, and that was for the fees in the underlying case. If they have any defenses that do not involve the malpractice they claimed in this case, they're preserved all of those defenses wherever the case was going to be, whether I had to sue in Illinois or now whether Judge Peacock's order has been reversed and we're going to go into the trial court and go get the $70,000 that they didn't pay for the underlying work that we did in the DeRuin case. And if they have any defense, but you can't sue me anymore. That's what the release said. And the release was crystal clear at all damages that would be awardable to DMI in a final judgment, full and final resolution of any claims that were asserted or may have been asserted in this action. And then they execute a release of all claims that were asserted or may have been asserted by DMI in this action. I don't want to then end up settling this case and somehow leaving them with a compulsory counterclaim or a contract claim in a separate, in my fee claim, whether it's a counterclaim or an Illinois complaint, and leave them and litigate this whole issue all over again. Why would I fund them $5,001 to sue me in another forum or to use the same argument a second time? So I made sure we're done. There's no other parties. There's no other cases. There's no third case that's going to be filed about something else. If it had something to do with what you pled in the lawsuit in this malpractice case about my malpractice, it's gone. Ipso facto, done. I don't want to hear about it again. And then you can make whatever claims, block billing, all the stuff we hear all the time. You block billed, you have clerical work, you double billed, your rates are too high, whatever the objections they have to the fees, you didn't comply with our contract with respect to billing, which they stand on all the time. You didn't get it in 24 hours. You didn't do this. Okay, fine. That's fine. But you're not going to sue me for this malpractice again. I'm not going to do this again. I tried to tell you before you filed the lawsuit, when you filed the lawsuit, when you took my deposition, when you took the other depositions, when you went to the court, and now all of a sudden you're going to sue me again. There's nothing in that release, nothing in that proposal for settlement that impaired, impeded, infringed upon Dove and Mule's ability to understand that when they settled this case, if they were going to do so by accepting my $5,000 offer, that it was gone, that they could not raise that issue again. I was not settling my claim against them for fees. There was no mention of that. There was no mention of any other case, and there's no other ambiguity. The case that that Judge Huey was relying upon, it's just confused. I mean, he says something that I just can't even understand. He says that in substantially a form against this backdrop of multiple claims between the parties, not all of which were or should have been raised in this case. What's he talking about? Not all of which were or should have been raised in this case. If you have a malpractice case, I don't care whether you call it negligence, breach of fiduciary duty, the cat's meow, it's this case. You got to file it in this case. And that's what it is. So he says, well, there's other cases which were not all of which were filed or should have been filed. What are you talking about? I don't know which other cases you're talking about. Leads to a conclusion that something is ambiguous.
So, Mr. Solomon, because whenever we issue rulings, we always have to be concerned not only with the litigants before us, but what we are saying about the law. It seems if you're raising the question about a proposal for settlements ambiguity, would it be a correct assessment or statement of the law to say the trial court should be required to elucidate what the ambiguity is in a way that can be readily comprehensible? Is that a legal rule that you think would be supported by the law?
I think that given the way our Supreme Court is going, and all of the things that are coming out, including the new 1.510, that it is incumbent upon a trial judge, not only under existing jurisprudence, but under the way of the world in 2021 and 2022, to elucidate or articulate the specific things that the court finds to be problematic or an issue or remaining an issue in the case. I don't see one in this case.
Even if that were done, the question of whether this written document was ambiguous would fall to us de novo, regardless of what the judge thought. I mean, what the judge expresses could help us in guidance wise, but that would not be that wouldn't render it an abuse of discretion in terms of the interpretation of the document.
I agree. I don't have any doubt that that's the case. And this court is to interpret that, because it would be effectively like an interpretation of a contract. It's a matter of law for this court to determine. And I have no problem with that, because if there were any, and maybe the answer is to your question is, if the court were relying upon something that was in the record, hidden in the record, obscure or pieced together in some way that caused the trial judge concern, that certainly would be helpful to all of us, to the litigants and to the court. In this case, there were no other things. There was an underlying litigation malpractice case that requires but for. We're not talking about you prepared a document that missed a paragraph, and therefore I ended up having to pay double tax. I mean, that's not what we have here. It's whatever happens in the litigation, and she can complain about whatever happened 10 days before, 3 weeks before. It all happened before. and she's only seeking to complain about something afterward. That's what I consider to be ambiguous. We're trying 3 separate cases, depending on which forum or which stage of the proceedings we're at. The complaint is 1, Copland is 2, the appeal is 3, and none of them make any sense. And all I was doing with the offer of judgment, which could not have been any cleaner and clear, every release I have ever done in 41 years says any claims that were asserted or may have been asserted. That's compulsory counterclaims, permissive counterclaims, collateral actions, whatever it is that you got something in there. But if you've got a complaint about my fee, that's a different case. I didn't say that because that's my claim against you. You're not suing me for the fee. You're suing me for the malpractice, and that's the claim by DMI against Solomon Law.
Mr. Solomon, I don't recall whether you said whether you wanted to reserve a rebuttal, but you're down to 5 minutes. So
I've
do as
said
you please.
my piece. I'll reserve the rest.
Okay, thank you. Mr. Fitzgerald?
May it please the court, Elizabeth Fitzgerald for DMI. I'm just going to address first the proposal for settlement and the release, since that was just what Mr. Solomon was discussing. So he seemed to think that it's very clear. However, there's some inconsistencies within the release itself, because thing is, release attached to the proposal for settlement states that it relates to matters arising from, relating to, or having any connection whatsoever with any act or omission relating to the case styled Devamule Mortgage Inc. versus Solomon Law Group, PA. So the malpractice action. And then the release in this case also provides that it forever extinguishes without exception every known and unknown past, present, and future claim against Solomon Law related to Solomon Law's involvement in the case styled Universal American Mortgage versus Darum, the Pasco County circuit case, the Darum foreclosure. So that is, it's not just confined to the malpractice action. It's bringing out anything. And at that time, when DMI was served with—
Hold on, Ms. Fitzgerald, when you say anything, what do you mean? It's not tied to the malpractice. It can be anything.
What were the possibilities?
The possibility that it could be anything arising out of the Darum foreclosure during the representation, not just the malpractice.
What else was there?
Well, there was the counterclaim that was dismissed, and as recently that dismissal was reversed.
That wasn't an action against Solomon. That's an
action against DMI. It's an action against DMI.
And didn't this specify this release and offer specify this has to do with the actions the other direction?
Right. The DMI has against Solomon Law. Correct. Right. So if with this, with the counterclaim that was just reversed, the order of dismissal was reversed, there will be defenses to that, and perhaps a counterclaim to that. So based on exactly what Mr. Solomon was—
Are you suggesting that if DMI had agreed to this PFS and released, that it would have waived its defenses to the counterclaim? Is that what you're arguing?
Yes. That was the idea. And I believe Mr. Solomon had said that, no, that's not what was intended, but that was not clear in this release. And so that, for that reason, is why we believe it is ambiguous, and that the trial court was correct in its ruling.
I don't have it like right in front of me, but I don't recall it saying defenses. It just said claims, causes of action. It's kind of the usual litany.
It says, extinguishes without exception every known and unknown past, present, and future claim, right, and demand that DMI has or may have against Solomon Law related to Solomon Law's involvement in the case in the Darum foreclosure.
But, let me ask you this. If there's some, without conceding that there is an ambiguity there, in itself that would have justified rejecting the proposal, isn't that release attached to the proposal for settlement? subject to interpretation in light of the terms of the proposal for settlement, which begins, this proposal for settlement is made to resolve all damages that would otherwise be awarded or awardable to DMI in a final judgment rendered in this action. Doesn't that language, affect the interpretation of the release to the extent that there might be some question about how far the release goes?
I believe so. When I looking back at the what the proposal says, resolve all damages that would otherwise be awarded or awardable to DMI in a final judgment, in full and final resolution of any and all claims that were asserted or may have been asserted by DMI against Solomon in this action.
In this action,
In this
not
action.
in the Solomon's contract claim for fees.
Right. And at that time, when this was served before the expiration, I think it's important that DMI was served with this proposal for settlement on the 9th of July 9th of 2020, and the order dismissing Solomon's counterclaim, it was issued on the 22nd of July 2020, so before the expiration of the 30 days to accept the proposal. So with that also, I think, added some ambiguity to
The counterclaim could not have resulted in the award of damages to DMI. The counterclaim could have been resulted in the award of damages to Solomon Law, plus or minus whatever happened with any affirmative defenses, correct?
Correct, but I think the concern was it was not clear that affirmative defenses or counterclaims to the counterclaim would have been okay and would have been permissible at that point had the proposal for settlement been signed. And then I will just move on to the 57105. We're looking at an abuse of discretion. There are many facts that are.
Well, let me ask you the same question I asked Mr. Solomon.
Sure.
What do you think, Judge Huey, what can you propose was what Judge Huey believed made this a close case and that tipped it in favor of denying the 57105 motion?
Well, I don't want to presume, but I think there were a number of facts that were unrefuted that were there to for, and I think it was, and the reliance was on the DeRune foreclosure opinion from this court was gone through significantly during that testimony provided.
This was poured over in the course of this.
Correct.
You get that?
Okay. Yes, and so perhaps that could have been it. But I think there were sufficient facts there to plead a case for legal malpractice or breach of fiduciary duty, and especially in light of the DeRune, the foreclosure opinion, that saying that but for because Universal failed to address the waiver issue by reply to affirmative defense, the trial court could not award Universal relief on such a basis. Perhaps that was the issue that made it a close call. I don't know. But I'm not sure if I answered your question.
No, and I guess maybe what I was looking for in both from you and Mr. Solomon in that regard is was there anything else, I suppose? Because clearly that opinion starts off, says, you couldn't assert the waiver, you waived it. But then said, but the the facts that you would rely on for waiver and that you did wouldn't do it. Were not sufficient. So, I mean, it was kind of went both directions, but I'm, perhaps I haven't prejudged, but could see why Judge Huey would say that made it a close call. But was there anything else?
I can't say for certain what else would make it a close call for him. I think I know that Mr. Copeland did provide evidence or testimony. Mostly Judge Huey inquired of him, so he knew. So Judge Huey was fully informed of all the issues and facts which he felt were important to this particular issue. I know that while Mr. Solomon did testify as to his interactions with trial counsel prior to the filing of the action, but there was no, expert testimony provided by Solomon Law that would contradict the testimony provided by Mr. Copeland. But again, I do not know what made the court decide that it was a close call.
Right. Who knows what lurks in the minds of circuit judges? But this is an abuse of discretion standard here, correct?
Correct. It is an abuse of discretion standard. And so for what Solomon was required to, for the purposes of the 57-105, was required to establish that DMI and its counsel knew or should have known that its claims were not supported by material facts necessary to establish the claims, or that the claims were not supported by its application of then existing law to those material facts. And they just didn't quite do it. The claim brought by DMI is supported by material facts. We have the amendment to, and it really just falls in line with a lot of the same argument that was brought about in our previous oral argument, which was they filed a first amended answer and affirmative defenses. They were on notice that that first amended answer and affirmative defenses had a specific denial that would have required a plaintiff to prove substantial compliance with the face-to-face meeting or plead and prove an avoidance of the noncompliance defense. Contained within that amended answer and affirmative defenses, the fact that wasn't done, there weren't any communications that were much delayed after getting the specific denial and the affirmative defense were initially raised. For about 9 months before any specific documents were requested, and then that's kind of a pattern through then there's an opening statement as a non-jury trial, and the opposing counsel is arguing that there's no valid excuse for Universal's noncompliance with the face-to-face. They haven't raised it in the pleadings. And even though despite that, Solomon Law knew that, hey, maybe we need to file something to be able to raise this, to file reply and avoidance and noncompliance defense. That didn't happen. And then on appeal, then Solomon Law argued that Universal presented competent, substantial evidence that the Dayrens waived compliance with the face-to-face meeting.
Well, of course they did. Of course they argued that. That's what lawyers do, but that's not what the court ruled.
Right, that's not what the court ruled. Well, that's correct, Your Honor. That's not what the court ruled, but if it was going to be argued and to even have any chance of that being a valid argument, it still had to be framed by the pleading. So that's where, we believe there were sufficient facts. And there had to have been facts underlying the assertion too. I mean, and what facts were presented, this court held were not sufficient in any event, correct? Well, and maybe you could help assist me with that, because the way I read it was that there was no that the court was viewing the evidence and through the lens of the specific denial, specifically with the statute and the exceptions, the statutory exceptions to compliance with that. when found that evidence of the phone call with the lender, between the lender and the borrower, did not suffice to meet one of those statutory exceptions. But when viewed through the lens of the affirmative defense raising the same thing with the waiver, that couldn't be considered at all because it wasn't pled. I did not, from my reading of it, and I could be wrong, and please correct me if I'm wrong, from my reading of that.
It's printed out there so everyone can interpret it. So yeah.
So that there was no real comment on whether that particular evidence that was submitted would be sufficient to establish waiver. I didn't believe there was a comment from the court on that particular thing. I believe there's a comment that it did not meet one of the statutory exceptions. So that's my reading of it.
I'll go back and take another look.
Okay. So, and again, just then it's not but for Solomon Law's negligence and failing to file or apply an avoidance to the non-compliance affirmative defense, DMI would not have suffered the full extent of the damages that it did. And by that, I mean the legal fees awarded to the day room's attorneys, which included pretrial, trial, appellate, and post-trial fees and costs. And we know that $124,000 of those were just associated with the appellate fees, post-trial fees. So that is why we believe that that the court, although it may have been a close call, was correct in concluding that that the motions for 57-105 sanctions should be denied.
Thank you, Mr. Fitzgerald.
May it please the court. I just
How about
briefly, as this court said in the DeRuin opinion, that this court is going to defer to the trial court's findings of fact when they're based on competent, substantial evidence, but this court's not obligated to disregard record evidence that disproves the lower court's findings or that reveals its ruling to be an abuse of discretion. In this case, the fact that we're having this discussion, with all due respect, Judge Northcutt, that we don't know what it was that was ambiguous or why there was an ambiguity, begs the question as to whether that could possibly not be an abuse of discretion. What could there possibly have been? You've seen the whole record. We've argued this whole record, and what makes it ambiguous is plainly presented on the 4 pages or 3 pages of the proposal for settlement that tracks 1.442, in which I had a hand in drafting. I think we've all participated in one way or another in dissecting that. And as Judge Huey points out, there's thousands of cases about this. I don't know what could possibly be confusing or ambiguous to DMI when it encompasses every claim that they could have against me related to this case. I didn't say all cases. I didn't say all defenses. I didn't say any defenses. And in this case, it was crystal clear, as Tom Cruise might say, crystal clear that this was not going to be litigated all over again in another forum based on my $70,000 fee claim. And the issue is, what facts were there that would show negligence? Ms. Fitzgerald very politely and articulately says that there were facts in the complaint. What facts? What was it that the discovery that we didn't take that would have shown, that would have related to something to show proximate cause? Because don't forget, it's not only that they have to show but for, but they have to show that there's going to be some result at the end that's going to be the proximate cause of something that we did. The fact that this case was lost and it was litigated the way it was a client function, and you can't ignore the partnership, if you will, between lawyer and client. They're not claiming that we didn't do something they told us to do, or that we did something that they told us not to do. And they were involved in each of these processes. So, and my last point, without belaboring it, is under the proposal for settlement, nobody asked them to waive their defenses. And Ms. Fitzgerald, even after Judge Northcutt, you asked her, or Judge Lucas asked her about what counterclaim. What counterclaim are you now going to continue to preserve against Solomon Law based upon this settlement and the remaining fee claim that you didn't pay because you thought that we committed malpractice, or that you would just wrap it up and get a discount of some sort on what was otherwise owed? I mean, what counterclaim? They're making this stuff up. And and there's no substance to any of it. And Judge Huey never pointed any of it out. What he says, if we take him at face value, to answer your question directly, Judge Northcutt, is that he says that because there's multiple claims, and because we say that the release is going to be substantially in form as attached, that it's limitless. Limitless. The options as to what that could possibly mean is limitless. Really? After you get the preamble that complies exactly with 1.442 and they don't claim otherwise. Thank you.
Okay, thank you both very much. It's always a pleasure to see both of you. In order to leave our courtroom, you click the leave button on your Zoom screen. And once you do that, you'll be gone and we will be adjourned.
Thank you.
Thank you.